the most interesting thing about this was the Attorney General got involved. They filed amicus briefs supporting the defense. And then the California District Attorneys Association of statewide DAs joined with the Attorney General. They all wrote amicus briefs against our office, saying, we think the defense is correct. And so I was going against everyone and just trying to do my job and reading the law. And of course, we had to argue about what impact the Attorney General's opinion might have, how influential that should be. And we argued it's their interpretation of the law is no different than what the courts and all of us can interpret. So that's another takeaway from the case, right?
I had read about the amicus brief filed by the Attorney General's office. I was not aware that the Association of District Attorneys had also taken the same position against your office. That's very surprising. And I wanted to go back to your reference that you were surprised at the defendant Abbott Laboratories' position originally to file a motion to strike those allegations. And are you saying that? And I think you went on to say something like these allegations in the complaint here were no different than any other UCL complaint that the DA's office might have filed, but it was Abbott Laboratories here who almost stumbled upon this new idea that maybe there is no geographical limit to the court's orders here, should the court rule for the district attorney, and it could be a statewide litigation. And that wasn't necessarily in your mind when you filed it, but maybe Abbott Laboratory, this is kind of like a cell phone. They brought up the issue. They kind of teed up this issue about the extent of the relief that could be afforded on this complaint, and it turned into a California Supreme Court decision saying, yes, the district attorney can file essentially statewide litigation.
Yeah, I think you summarized that pretty well. The shocking part being, and this is for your trial lawyers, right? When you're at the pleading stage, it's very rare you're talking about, what the amount of damages in your world is going to be at the pleading stage. And you're going to be litigating how much in damages you can get. That is not what should be happening at the trial court level. And our trial court judge said that. She's like, this is premature. And there is no basis to strike the word California out of the complaint. Whether you are right or wrong, it's not time to address that issue at the pleading stage. And so it was just interesting that they pushed it at that level. But statewide, there had been a few other cases where the issue had come up. And of course, there was a dispute. The Attorney General was taking a position contrary to our office. And so they believed that it was something that they should push. And obviously, if they would have won on the issue, they would have drastically narrowed down the number of violations and possibly the amount of penalties that they could be subjected to in our case. So I could see from their perspective why they were pushing it. What I was just most surprised about is, I worked for Justice Huffman, actually was one of the Court of Appeal justices in law school. He was on my panel and he went against me. And I learned from him, the standard of review. Are you at the pleading stage? And you're looking at what the standard is the most important thing in all the work that we do as lawyers. And we shouldn't be striking out truthful, factual allegations at the pleading stage based on what the remedy should be. And so I was just completely surprised that the Court of Appeal took the case. And once we lost, we knew we had a good chance to get to the California Supreme Court. And now, thankfully, the issue is now resolved. And there are many, actually past judgments that would have been affected because our DAs statewide have been filing these cases for decades. The UCL is not new. And there would be many judgments where DAs had gotten relief for the public that would have had to be overturned. This would have been a massive change in the law. And I always put on my defense hat, because I was previously a defense litigator. I'm like, why would you guys want to face 58 separate lawsuits? Why would the defense really want that? So I thought it was short-sighted by the defense to have done this as well, because they're shooting themselves in the foot long-term and they wanted to get an advantage in this one case. But now we know it didn't really change much at all. And we are operating as statewide prosecutors the same way we always have. So I don't see this dramatic increase in cases or any of the things people said were going to happen. I don't see it. I haven't seen it. And we continue on with the Supreme Court decision guiding us now.